Hi.
Okay, there I am.
Oh, there you are. I was starting to get a little nervous. I thought, did I misunderstand there was class?
No, I
Yeah,
was running to get something after I started to log in.
yeah. Uh,
Must
so we
have
have
the
class
coffee, you know.
today and tomorrow, but not Wednesday and Thursday, right?
Correct. And Rabbi Karsh will confirm that.
Yes,
I'm confirming it.
confirming. Rabbi, are you flying to New York this week?
Yeah, I am.
I hope so.
I am. Well, we'll see. Yeah, I don't
Yes, good
know.
luck.
Yeah, I have no idea. I'm assuming I am.
Good luck. Good luck.
Thank you. Um, that 1287, which is that he prohibited the judge from accepting the testimony of some relatives for others, and that is his saying, fathers shall not be put to death for children. And the received explanation appeared in the Sifri that fathers should not be put to death from the testimony of children, no children from the testimony of fathers. So this mitzvah actually, it corrects it protects against a common mode of getting to people or punishing people, which is to threaten their family. Like if you go after their family and, like, let's say, torture them or threaten them so that they give testimony against one of their relatives. I mean, one reason you could say why you shouldn't do this is because people tend to not be truthful when they are talking about family. If it will protect their family for them to lie, then they tend to not be truthful. But the other thing it ends up doing is preventing circumstances where the justice system would put pressure on one relative in order to get to another relative. Let's look at this one again.
As you're looking, it just occurred to me that this was
Yeah.
the exact situation that Euthyphro found himself in.
Yusufer? Yeah.
How? I thought he was. Oh yeah, he's
Euthyphro,
testifying. He was testifying against his father-in-law.
that's
Right?
his father.
Was it his father or father-in-law? Was his
Father.
father? It was father. Yeah, because he killed a servant or
Slave.
something, right?
He
Yeah, he
killed
killed
a
a slave, and that's why he was there. He was at the king's palace or whatever, the emperor's palace, to testify against, I guess you're saying, his father
Right.
when he
It
was
was
there. Yeah.
the death penalty.
Yeah. And that's when Socrates got him. It's one of my favorite moments when he, not just the discussion, which was fascinating, but the end when Euthyphro is just like,
Gotta go.
yeah, I just remembered.
And of course, my
It's just
birth.
funny because it's thousands of years ago, and that's just like one of those moments that could have been today. Yeah. Okay. He prohibited a judge to declare punishments by way of strong conjectures, and even when it's almost certain. For example, this one man is running after his enemy to kill him, and in order to escape from him, he enters a house. But when the pursuer pursues him, and the other enters after him and finds the pursued in death throes, while his enemy that was pursuing was standing over him, the knife dripping with blood in his hand, the court may not kill him from the angle of executing the punishment, since witnesses are not testifying that they saw the killing. So when it comes, again, we saw this before, but when it comes to murder, you actually have to see the person kill him. Now, I wonder if what you would do about a case, let's say, of poisoning, because let's say it was poisoning and you saw the person drink something and then suddenly they looked like they are struggling and in death throes, and then they die. And you saw this person put something in the food beforehand. You saw this person put something in the food beforehand. Then you saw that the person ate it and then died from shortly after they ate it. And you check the bottle, and the bottle is definitely poison. So is that called seeing the person kill the other guy? Because there, you've seen all the steps it takes to kill him, but the final death, which is part of the death, which is the poisoning, happens outside of your view. It's inside the person's body. So even though you could say that you saw this person do everything to poison him, but did you see the actual poisoning? Like, in this case, because poisoning is a physiological reaction to whatever he put in the food, and that physiological reaction is happening outside our vision? Or do we say that poison is just like a knife, and that it's because here, like, you see everything and up, but you don't actually see him stab him in this case. So would you say that's what happened in a poisoning case, or is there some difference, because in the poisoning case, that last bit is happening away from your view? Yeah, so that's what I'm thinking about right now. So it says, do not kill an innocent righteous man. And in the Mechilta, they said, if they saw him pursuing another to kill him, and they warned him and said to him, he is an Israelite, he is a son of the covenant. If you kill him, you'll be killed. But they averted their eyes and found the one pursued in his death throes, the knife dripping with blood in the hand of the murderer. I might understand that he's liable for the death penalty. Hence, we learn to say, do not kill an innocent righteous man. Do not dismiss this and wonder about this law, for among possible things, there are things that are very likely, things that are very unlikely, and things in between, so that there's a wide spectrum of what is possible. And if the Torah had permitted declaring capital punishment in very probable cases, when it was very close to actuality, like the case of our example, we would declare the punishment in that which is a little removed from this, and eventually also in that which is far removed, until they would declare the punishments and kill people with a weak conjecture, according to the imagination of the judge and his thought. Therefore, he be exalted, closed this opening and said that he did not declare the punishment until witnesses testified that they know with certainty that this one did the act without a doubt and without any guesswork at all. So again, in our case with the poisoning, because there could be something where it looks like somebody was poisoned and they actually died from a heart attack. Now, is that likely that it happened? No. It's extremely, extremely unlikely that he had a heart attack before he died. But isn't that similar to this case, to the case with the murder, where the Rambam is saying it is, he called it very probable cases, when it is very close to actuality, which I to certainty. That's what he means. It's close to certainty, but it's not certainty. So for some reason, this is a case with killing. With other things, it may not be. There might be other areas of law where you don't actually have to see every piece of it in order to decide. I'm not sure. I mean, I know, like in the cases of somebody witnessing adultery, for instance, you don't have to see every detail of what happened. And so the question is, okay, so I have two questions. One question is, what are the exceptions to this? In other words, are there other areas of law where we don't require this degree of certainty? And the other question is, what would you say about a case of poisoning?
What about a case of somebody injects somebody with a needle?
Yeah, same kind of thing. Same kind of thing. So they inject them with a needle, and then, because, I mean, first of all, we have all sorts of things like this that are not this close to certainty. But for instance, when people are trying to find a cause for autism, or let's say a cause for death, and the person has just taken a vaccine for something. So let's keep it the same. So vaccines, there's some people who think there are certain vaccines that cause autism. There's some people who think that there are vaccines that they might say the vaccine is dangerous because this person took the vaccine and they died right afterwards. So now it's possible that is what happened, but there's a common mistake that people make when it comes to cause and effect, which is they assume that just because one thing happened before the other, that thing caused the other thing to happen. But it could be they're just adjacent. Like, I forgot if it was that English philosopher who said something about Big Ben striking and then something else happening. Oh, like he sneezed, and I don't remember what. There was Big Ben sounded and then something happened right afterwards. So do we say that just because Big Ben sounded, that caused the other thing to happen? No, it's adjacent to the thing that happened, but it's not the cause of the thing that happened. So that's the area here, like that you would say with that injection, is the injection what caused it, or is it just adjacent to it? Now, I guess you could say that even with stabbing. Let's say somebody stabbed somebody. I don't know. That one, stabbing is very close to direct. But poisoning doesn't seem as close to direct, or Sam's example of an injection. All right. And the example about this is is such as if one testifies that he did work on Shabbos and warned him, and the other testified that he worshipped idolatry. Oh no, that was two witnesses. Yeah, so then he went to, and likewise, when two witnesses testify to two sins, each of which has a death penalty. For example, one of the two saw him transgressing one sin alone, the other saw him transgressing the other. Behold, this one is not killed. Even though, again, so this person, again, he said, like, for example, this one testifies that he did work on Shabbos and warned him, and the other one testified he worshipped idolatry and warned him. This one is not stoned. So even though there is like a common, there's a common thing about which they're both testifying, which is this man did something that is a death penalty, an action that brings a death penalty. So you could say that both idolatry and Shabbos are subject to the death penalty. And so we have two witnesses who are telling us that he did something that will bring a death penalty. That's not good enough. They have to, it has to be two witnesses that warned and saw him do the exact same thing. So they may, their memory be blessed, said, if one testified against him, he worshiped the sun, and the other testified against him, he worshiped the moon. I might understand that they combined to constitute the necessary two witnesses. Hence, we learn to say, do not kill an innocent, righteous man. And here, it's even more close, because they're both testifying he worshiped idols, but they're testifying about a different act of worshiping idols. They are not talking about the identical act. They did not see the same thing, and therefore the two witnesses, the result cannot be that the person is put to death. Okay, so
Rabbi,
yeah,
here's another case. Let's say two witnesses witness a guy hitting another guy, and one says he meant to kill him, and the other one says no, he didn't mean to kill him. It was, accidental or
so
something.
that would have to be that he talked to them, like he talked to them, right? Like that would have to be that they spoke to him. Like, let's say they warned him.
Yeah. Oh, they have to warn
Right.
him,
So they have to warn him. So let's say the one guy warned him about not hitting his friend, and he said, I'm going to hit him. I don't care. And the other guy warned him about killing his friend.
Yeah.
So, and he said to the other guy, no, I know it would be killing, and the punishment would be XYZ. I'm still going to do it. So there, they see the same action, but they can't testify to the same thing. They can't, like that guy who warned him about hitting the guy cannot testify that the guy knew he was going to murder him. So therefore, the other guy is not going to be able to combine with him.
Right.
So even though the action's the same, and also it has to be that he didn't hear the guy say back to that other guy who warned him that I'm going to kill him anyways. All right, so now I just want to, so the Rambam. If I speak this into perplexity, it doesn't give sources.
Rabbi,
Yeah.
I just want to ask you, is this a situation where that we learn about Arei Miklat?
So this one of the so let's say, the question is, can we want to charge him for murder, but we don't have enough for murder, so can we get him for manslaughter? So that might, yeah. What is that now that you bring this up, I don't remember. That guy who kills somebody by accident, did he have to be warned? The guy who goes to the Ir Miklat, to the city of refuge, did he have to be warned? Did somebody have to say to him, You
I
know,
don't,
you're,
I
you're,
don't think so, because that it's not by accident. If he's warned, then he's still doing it, and now it's on purpose.
well, somebody could have said to him, what you're doing is very dangerous. It could, you could hurt somebody like that. The way you're chopping that wood is very dangerous. There are people walking around. Let's say somebody said that to the guy. Look, you are reckless. The way you're chopping wood is dangerous. Somebody could walk around here and you could end up killing them. And then that happens afterwards. So he could still say, I never intended to kill somebody, but in a sense he was warned. But I think you're right, but then it's sort of interesting that this guy's going to get a punishment from Beis Din like that, and he wasn't warned. All right, we have 3 questions. I'm going to start with that one because that one does the accidental killer.
Is it possible to warn somebody about negligence? Or is that sort of something that's always, like they talk about a parapet? A person isn't, but it's not.
I mean, but but somebody could just say, like I did, like somebody could say, what you're doing, is very reckless. Look at the way you're chopping that wood. That is extremely reckless. I mean, I remember going to a shooting range with rifles. So, one of the common things that the people in charge of those shooting ranges are looking for is somebody who doesn't understand the safety protocol when you're holding a rifle, let's say, or a pistol, that specifically that you can't point it at other people, even if you're not intending to shoot at that time. That's considered like a major faux pas. Like and so let's say that happened at a shooting range. The guy has his rifle and he's not planning on shooting in that moment. And he just turns to talk to somebody, and the rifle is like pointing right at the person who he's talking to. So he will be shouted at by everybody on that shooting range to turn around and to never point his rifle at somebody else, no matter what. Now, let's say they all shouted at him and they said, do not ever do that, pointing your rifle like that. You could kill somebody. And then he just does it and kills somebody. Would you call that warning?
Yes,
I think so.
yes.
David, you're not sure?
And I mean, if you have a hazard in your house, or take the case of the faulty ladder, it's the same thing with the axe. You didn't check your axe carefully enough. It wasn't, well, I don't know how you determined that, first of all. And
Yeah.
I don't know. It's
Yeah,
a
so I think you're right, but I am just not. It sounds a little bit funny that you can get punished for something and never be warned. That's all. An accident killer is required by halacha to go to a city of refuge. The core halachic process for exile revolves around the nature of the act, whether the killing was truly accidental, unintentional, without deliberate malice or neglect, rather than the presence of prior warning, which is only a requirement for capital crimes, but not for unintentional manslaughter. A person who kills oops, I lost it. I was just there. Darn. A person who kills accidentally must stand trial if the court finds that the act was truly inadvertent and not out of gross negligence or intentionality. Then the exile to a city of refuge is mandated. There is no requirement that the killer receive a prior halachic warning, as is necessary when a Beit Din imposes the death penalty. So this is.
Erase it. I don't remember erasing it. Let's go on again. I don't get it.
You're on silent, right?
All right, I just muted everybody, so if you want to get back on, you can unmute it. All right, so he who fatally strikes a man shall be put to death. If he did not do so by design, but God led him to it, then I will assign you a place for which you can flee. That's in Shmos. The section in Devarim never even alludes to any mandatory requirement on the part of the killer to remain in the city of refuge. Residence in the Ir Miklat remains an option for his protection from the avenger. In our parsha, however, the Torah clearly demands that he remain away from home in the city of refuge. All right, whatever. So he doesn't talk about that. All right, so perplexity is just saying it, but they don't have a direct source of it, at least that I can find. All right. Prior warning in halacha. What constitutes a prior warning in halacha? A prior warning in halacha is a formal caution given by witnesses to a person who's about to commit a crime, informing them clearly that their intended action is prohibited by the Torah law and specifically the punishment they will incur if they proceed. This warning must be delivered immediately before the commission of the act so that the individual is fully aware of the legal and spiritual consequences. Warning serves multiple purposes. It distinguishes willful from unintentional. It provides deterrence as the person is given a direct opportunity to avoid. It is a prerequisite for the baiting to impose penalties such as the death penalty or lashes for which Torah requires absolute intention. Yeah, so I guess that itself, that first point, it distinguishes from willful, it distinguishes willful from unintentional. So the whole point we're saying about this guy is that it's unintentional. It's still, it's negligent, but it's unintentional. Yeah, so it has to be. I guess it has to be that he's not being warned.
In the first case that was considered, they grouped together murder and gross negligence in one area. And if it wasn't either of those, then you worried about non-negligent manslaughter. But there's an area between.
There is?
Yeah, supposing I gave a place that's a bit booby trapped or not well constructed. I didn't tell them. There's no witnesses to how I constructed my shack, and the guy walks in and dies.
You have to be warned?
You
In other words,
no,
you can kill that way?
Well, no. Well,
it wouldn't be permitted. The question is, do you get the death penalty?
Right.
yeah.
Or do you get gullus or whatever?
But what about in case of gross negligence?
Right.
Yeah,
so we have to have you have
No.
to have a scenario that
Yeah,
you're
right.
And so question is, what would be the scenario? Was he warned? What distinguishes gross? Is it like that if it is, what would be the distinction between, let's say, gross negligence and unpremeditated murder?
Question.
So there obviously,
But there seems to be a distinction.
What if he's digging pits all around his house because he's going to fill them with something, but he doesn't put a fence around it or anything, and then someone comes and falls and dies in it?
He's
I
liable.
mean,
He's liable.
but yeah, I guess
He's
that's
liable.
like a parapet.
He's liable. No, that's more like shooting arrows.
Oh,
But also over there, we don't require that he's warned in those cases. Like, right? I mean, we don't certainly for monetary damages, we don't require that the person is warned.
No, no.
Right. So, but let's say in that scenario, somebody fell in and died. So, yeah.
Well,
So what?
well, if he warned him before, I have lots of holes, then he's okay. But if he doesn't tell him, it's reminiscent of the guy, shooting arrows. If he and invited somebody over, if he didn't let him know he was shooting arrows, he's skying. But if he did let him know he was shooting arrows, the guy enters at his own risk. I remember a case like that.
All right. Just looking at the other question here. Are witnesses seeing enough? It's funny. I'm like thinking to myself, this takes too long. There's got to be a way to do it shorter. The fact that it already is so miraculous that it can answer everything, just already I'm going, wow, this takes too long. All right. According to Allah, a poisoner is treated differently than one who kills a knife or by more direct means of murder. The classic four methods regarding witnesses for the death penalty, Allah mandates that two kosher witnesses observe the murder act directly, see each other and hear the warning and the response confirming the knowledge and intent. This eyewitness testimony must satisfy strict criteria to convict a murderer and impose capital punishment. In the case of poisoning, it is generally more difficult to meet these stringent witness requirements because poison acts invisibly. What did I just do here? I did that in the same one. Yeah, okay. Poison is generally more difficult to meet these stringent witnesses requirements because the poison acts invisibly and indirectly over time, limiting what witnesses can directly observe. As a result, poisoners often do not meet the Talmudic standard for eyewitness testimony needed for the death penalty, make it challenging to execute capital punishment for poisoners. So that one's they cite the case of the poisoned sandwich. Okay, Rabbi Manning. Some time ago, an incident occurred involving a socially inept American student who became the butt of his classmates' derisive behavior. Matters reached a point at which one of the tormentors regularly invaded the express person's knapsack, stole the sandwich the latter had prepared for lunch, and proceeded to eat it himself. Endeavors to enlist the aid of fellow classmates in order to identify the thief or to prevail upon him to put an end to the practice were of no avail. Finally, the victim, who excelled academically as a chemistry student, took matters into his own hand and proceeded one day to lace his sandwich with poison. In the midst of an afternoon lecture, one of the members of the class became violently ill. In the course of the ensuing tumult, the victimized student revealed that what he had done, explaining he had resorted to the poisoning the sandwich in order to establish identity of the thief. Thereupon, the rightful owner of the sandwich administered an already prepared antidote. Thereupon, the rightful owner of the sandwich administered an already prepared antidote to counter the effect of what otherwise would have been a lethal poison. Many years later, one of the Jewish children who addressed that episode was by then a senior physician in Israel and attended seminars conducted by physicians by Rabbi Yitzchak Zilberstein of Bnei Brak. He asked Rav Zilberstein what the halachic analysis of such a case would be. His response was, oh my gosh, he said, not only is it permitted, it's a mitzvah to do what he did. And how is that possible? This started a heated halachic debate on the merits of such a response. In a one-line response by Reb Chaim Kanievsky, he stated that Reb Zilberstein's position was legitimate. He later confirmed that if a thief was gaining entry into a building by a rope, it was legitimate to replace the rope with a weaker one, which would snap, causing the burglar to fall and injure himself. Now, this is about setting booby traps. And then you get to David's thing, indirect harm as opposed to direct harm, proportional harm in response to a theft. Oh, that is a shocking thing he said there. Limitations to owners' right to set traps on their own land. Saving a thief. Yeah, it doesn't, I don't know if I think this might be another example of perplexity guessing, because I don't see the section here where it would talk about that. It's close, talks about a lot of other interesting things. But yeah, so that was, so we had that we have now decided that in the case of accidental killing, that there doesn't have to have been a warning of any kind beforehand. As far as whether or not the poisoner is the same as one who kills by knife, we see that it looks like proximity is guessing. I mean, not proximity, perplexity is guessing that it's not the same, but I don't see a source for it not being the same. All right. Yeah. Oh, yeah. The other one was, oh, yeah. And then we did get, I think, a part answer to that question. We got enough of an answer to see that this stringency that you have to be warned does not exist in other cases besides capital punishment or lashes. But if it's something that is not going to involve capital punishment or lashes, it sounds like you don't need this degree of certainty. Also, oh yeah, and then there was some question as to, or at least there's a discussion about this. In the end, it might be completely resolved, but at least there was a discussion or reason to believe at first that the going to a city of refuge is not a punishment per se. It's just a choice that he can make in order to save himself. But it did look then that eventually it is considered to be a punishment. Because if it wasn't a punishment, then this whole thing, then obviously you wouldn't have to be warned, you would think. Because he's not really being punished, he's just being saved. He's getting an opportunity to be saved. But if it's a punishment, then it would be right to ask that question. But it seems like it would not be required in that case. So again, it would end up that only in a case of capital punishment or lashes do we have this requirement of warning, and do we have the requirement that the witnesses see what happened?
Rabbi, what's the commandment we're on right now? I'm having a little hard time remembering what the
290.
Yeah,
Negative commandment 290.
and what's the connection with what we're talking about?
the commandment is he prohibited a judge to declare punishment by way of strong conjectures. So you can't, what we would call what do you call it? It's not direct evidence. It's, what's the word for that evidence when it's not direct evidence?
Circumstantial.
Circumstantial. Yeah. So you can't, when it comes to murder, you can't convict a person based on circumstantial evidence. The witnesses have to have seen the act. And even if they think they saw it because they saw this guy chasing after the other guy, running into, let's say, the house or a cave, there's no way for anybody else to have gotten in there, or for the guy, for anybody else to have gotten in there. And we get in there and we see the knife is blood stained. We still cannot kill the guy with capital punishment because it's not called seeing the murder.
Right, but
They haven't
but
actually
that's
seen
not
the
the case
murder.
for adultery, right? You said, I mean, if
Right. So adultery
goes to the house and he's been warned you can't be with this woman.
No,
They assume
that's to be a sota. That's actually not a court case. That's not a criminal case, because that's being decided in the Beit Hamikdash using like extra means, that water. So that's not a criminal case. That over there, you don't require all of this. You just require that there are witnesses that she was alone with a man in a place they could have committed adultery, after having been warned already in front of witnesses not to be alone with that man in that kind of place. So there you do the sota thing. But if you wanted to have a death penalty, because there's a death penalty for adultery. If you want to have a death penalty for adultery, they have to see them actually making love. There's two witnesses have to actually see them making love, but they don't have to see what does it mean to see them making love? They only have to see that it looks like they're making love. They don't have to actually see, that what we would call penetration. They just have to see that it looks like it. So that seems to be different than the murder case, where you actually have to see the knife go in. Here you're seeing them act as if they are in coitus.
i.e., you have to look it through the window, or you just can't
Right.
assume it.
Yeah. Well,
You
you'd
can't
have
assume
to,
it because they're in the room together.
you have to either be in the room when they're doing it or see them through a window. And also, yeah, but you have to actually witness, but it's not the same thing as witnessing the knife going into the body, because you're not witnessing that. You're just witnessing them look like they're making love, but you don't know that for an absolute fact. But for adultery, that's not required.
And they were filming a porno film and you didn't know it.
Right. Or then let's say they were, and then you found out, let's say they found out that she's married. They didn't,
Yeah.
they didn't think she was married or something. And then, right. So in a situation like that.
Midsummer Murders, Rabbi, they always find out that they were having relations.
Yeah, I know it. It always ends up that way. Okay. All right. So that's this. I will say that last distinction I just made between adultery and murder. So Ramosha Shapiro, we were studying this with we were studying the murder case with Ramosha Shapiro in Shear, and there were quite a few people that were regularly part of that shear, maybe up to 50 people that were regularly part of that shear. But there was one person who came from the outside, and he didn't ask permission to attend the shear, which is, Ramosha didn't like that if you didn't ask him permission to sit on a shear. So right before he got to making the distinction that I just made between murder and adultery, right before he got to doing that, he just stopped and he goes, I don't know what to do. I don't know what to do. And one of the members of the shir went over to the guy and whispered in his ear that he needs to leave. And the guy goes, "Why? I didn't, I didn't disturb. I didn't say anything. I'm just listening. I'm just here listening." And the guy says, "No, you got to leave." And then he escorted the guy out of the room. And then Ramosha explained that when it comes to these issues, because there's a Mishnah in Chagiga that says that when you're discussing arayot, which is sexual crimes, you can only do it with a couple students, because it's very important that they don't misunderstand what you're teaching. So therefore, you can only teach it to a couple students at a time. So he said that what it means is that you can only teach it to students that you're regularly studying with, that will be comfortable asking you questions and will be there for any qualifications you make, etc. So he needed that guy to leave because he didn't know the guy. The guy's not one of his regular students, and he's not supposed to be teaching these kind of subjects to somebody who he doesn't have regular contact with and who's going to feel comfortable asking him questions afterwards, etc. So I'm just saying that out loud after we did that. Okay. All right. I am grateful. Next, we will move on from this to 292. Tomorrow, I think I just have to, it could be tomorrow. I have to end our class early. I'm sorry. I'm going to have to end it like at 11:25, which feels very short, but I have to take Sippy somewhere. And so I apologize about that. And thank you for putting up with my annoyance. All right. Okay. And
Thank you, Rabbi.
then Wednesday,
No class.
we're not meeting because I'm traveling to Rabbi Becher's wedding. Okay. Be well.
Nice. Okay.
Yeah, it says
Thanks.
something. All right. Be well, guys.
Thank
Bye-bye.
you. Bye.
All right.
Bye-bye.
Bye-bye.
Thank you. Bye.
Thank you. Bye-bye. Bye-bye.